Hello everyone and welcome to Module 7, and this is a very important turning point in the course because this is the point at which we first start putting all the pieces together. And you'll see that the challenge this week is really very much focused around doing a dry run for the assignment. It's again a cut down version, a simplified version of what you do for legal problem solving, in that while we've got all the moving parts of a legal problem, we've summarized all the principles involved. So you don't have to read any cases or read any legislation and understand that to solve the problem. It's literally focusing on how you integrate those different forms of analysis, how you integrate precedent with legislation and statutory interpretation, all those bits and pieces coming together. So hopefully, supported by what we've been doing for the last 6 weeks, you've been able to build your skills step by step, and this is where it all comes together. And as I said before, that's very important because your assignment will come out this week, whenever you get to see this, and this is what you're going to the task you're going to need to do for your assignment. Now, the reading materials for this week make a few overall comments that are worthwhile making a few notes on here. Obviously, you're going to get the most benefit out of reading them, but the first is the discussion of the idea of common law and the difficulties that we have in finding a fixed meaning. And I know for a lot of people who are approaching it from the end of the common law that you guys are as students learning about it, it just seems to be a very awkward way of doing anything, where rather than laying down clear rules, we've got this very complex set of principles that are being guided by finding the ratio and obiter and everything else. So it is a complex system. It is something that takes time and a lot of practice to get your head around, but it does exist for a purpose, and that purpose is not for teaching, and is even barely there for laying down future law. I mean, the primary purpose is resolving disputes between people in the court process. So the legal principles that come out of it are a secondary consideration, and teaching students what those principles are is a long way down the list of priorities. And that's why it's difficult. It would be much easier if someone was to come out with a judgment that said, here are my points, 1, 2, 3, here are the rules, here's the obiter, and here's the ratio. It'd be fantastic, but that's not the function of the way the courts work. So that's why we've done a lot of work in previous weeks in trying to explain it. And again, it's different to understand it in abstract as it is to come back and apply it, which is why we've been building those skills gradually through the challenges to do that. The other note I've made here is on the concept of uncertainty in law, and this is something else again which you'll possibly have found your opinions have changed from being a beginning law student to where you are now, or even, criminologists, from a beginning student to where you are now. And the struggle there, I guess, is that we would like the law to be very certain. Everyone would like the law to be certain. They would like to be able to look up the big book of law and to be able to find out the answer to a problem and apply it in a really consistent way. But because of our notion of rights and our notion that we do individual justice in individual circumstances, we have a lot of uncertainty within the law in some areas. And the areas that tend to get litigated are areas that there is uncertainty in, because otherwise they wouldn't get litigated. So it provides almost a kind of fake image of the way the law is, because if you spend enough time reading cases, you'll go, well, none of this is settled. The law is really, really random and chaotic and unsettled. The truth is 99% of the law is settled, and those are the things that are never litigated. We're only looking at that fringe area. In terms of litigation, in terms of appeals, we're getting a narrower and narrower area of the fringe parts of the law where there is uncertainty. So you can end up with a bit of a misapprehension about the certainty in law from the fact that you're only looking at the areas that are up for grabs. But the other thing is that then becomes your core skill, is to be able to locate that uncertainty and define the field of uncertainty. And one of the things that's often goes wrong with law assignments is that people will focus their attention evenly across all the elements and not really get to the point of what the uncertainty is. So, you know, if you've got, you know, a 2,000 word assignment and there are 5 areas, 5 criteria, and each of those have 2 sub areas, you know, you've got 10 points to look at. Suddenly you've only really got 200 words to look at each of them. And if you spread the attention you've got evenly and you discuss thoroughly all the areas that are certain, then the areas that are uncertain, which is where you're getting the marks, where you're getting the grades, because you're looking at how it all works, get the same equal attention to the areas which are like, yeah, duh, that's what the law is. Let's move on. And I do see that a lot, particularly in law students' assignments, that they devote, then they're cautious about focusing on the areas of uncertainty and do themselves a disservice by not identifying that quickly enough and just spending a lot of time faffing around with, you know, element 1 is this, element 1 is made out, this is okay, element 1 is fine, and then going into all the description of how element 1 is proven. You need to look for the areas where the good stuff is and start unpacking that. So there's a few reasons. One is the confidence and ability to use those skills. And I think another is that temptation that we get when we're facing a word count, where we sort of think, oh, look, if I can just like write as much as possible, I'll get to the word count. And not being discriminatory in a good way, not discriminating about the quality of what you're writing, because all you're worried about is, like, I've got to get to 2,000 words, I've got to get to 1,500 words. And we see that a little bit with introductions too. Sometimes people will write 500 words or more of an introduction. I say, this is just a waste. It is important to introduce a paper, but you can do that in a paragraph and just get it out of the way, outline your main points and move on to your analysis. And there's a piece of advice which is tear up the first page of your assignment, and it is so true. So many times when you're marking assignments, you get to the point where you just say, well, when are you going to start? When are you going to stop? It's a bit like watching a dog go to sleep and turning around and around and around and around and finally settling down. So this all leads us back to that idea of what's the good stuff in your analysis and where do you get to it as soon as possible, and that's where the uncertainty is, not where the things are certain. All right, the rest of the materials this week are really oriented towards supplementary bits of information, skills that'll help you with the process, that are not directly involved in the problem solving, but provide you support with understanding aspects of it. So the first thing we look at are theories of justice, and I think the major takeaway from that is that there are different ones, that we don't have one settled idea about what justice is. And I think that's important when you get into conversations with people who you're talking across purpose with and you're disagreeing with, and often you're comparing apples to oranges because you're coming from different perspectives. And one of the benefits of the understanding of theories of justice is you can identify, oh, that person's talking about distributive justice. No, I'm actually talking about a different form of justice. I'm talking about restorative justice. That's okay. We know we're talking about different things, and we can realign the debate to focus on those things. So theories, I mean, some people, you say theory and they just blank over and go, oh God, more theory. But theories are tools, and these are tools that are useful for you to help you in those other problem-solving processes. We also discussed the idea of access to justice, and of course any particular legal problem-solving problem does rely on the person who you are looking at having the resources to access the justice system. It all becomes quite redundant if you say, well, this is the solution to someone's problem that involves litigation, when they do not have the resources, as most people don't, to litigate a matter. So it's important to really focus on, not necessarily for an assignment, because we don't expect you to be able to calculate the cost of justice, but you should have that consciousness there of when someone's facing a problem with their neighbour, telling them that they have a chance of upsetting a High Court decision if they take an appeal to the High Court is not necessarily going to be a solution for that person. you can establish that there's an uncertain precedent, it could be overturned, but it also should be done with the consciousness that it's unlikely in this situation that someone is going to have the resources to take an appeal all the way to the High Court on a neighbourhood fencing dispute. And the last thing that we look at this week is a little bit on alternative dispute resolution, and that gives us an appreciation of, in the absence of direct access to justice, how we're looking at different alternative ways of providing that. So the use of online mediation, alternative dispute resolution, automation, all these things are being proposed as cheaper ways of trying to get the ability, access to justice for more people in society. So have a read of that. Important food for thought, very important food for thought for criminologists too going forward, to think about when we talk about disputes, that these days we're not just talking about people with money litigating, we're also looking at things like mediation. And if you're a criminology student, you will probably end up doing the Understanding Violence and Conflict unit that I teach, in which I will teach you how to be a mediator as part of the overall course objectives. So that's something to look forward for the criminologists anyway. Or I hope it is. I hope it's something that you find interesting, because I certainly do. Now, in terms of your check-ins for this week, I'll have a bit of a discussion of what we found. Now, obviously, we're getting later in the term and we've had quite a bit of a drop-off in people responding to the check-ins. And I'd encourage you to, if you have been a bit slack in doing them, please give some thought to filling them out. We've only had 18 of them this week. Admittedly, I'm doing this recorded lecture a little early, so we still have time to get more in before we talk about it in the workshop. But it is really valuable information, and it's not just a perfunctory customer survey, thing that we do for the sake of it. We do this because we're actually legitimately interested in the results. So yes, I encourage you to continue to do that. So our first couple of questions there were about confidence in communication techniques and professional responsibility, and the results there were really promising. That people have gone from being overall sort of averagely confident to non-confident to reasonably pretty good overall. So it's nice to see that. It's certainly nice to see people aren't going backwards and getting less confident. So that's very useful information. The next question is about what's important out of that last module's work, and definitely the idea of ethics was very, very important. One person said how lawyers function outside of courtrooms, and I think that's very interesting, because we do have that tendency to perceive law through TV, basically, and the idea is lawyers are spending all their times in court, and we've moved on to talk about the different sort of career paths for lawyers, and there's much more going on. But yeah, the overall feeling there was the idea of professional conduct, ethics, and all that was a very important theme that week, which is good, which was what we thought was important. In terms of speed up and slow down, almost everyone said it's about right, so it's nice to be in the Goldilocks position there. And then in terms of things that need further exploration, generally feedback was most people are pretty happy. Some things to discuss further: conflict of interest, that might be a good thing to bring up, or at least give you a bit more information about, I think, as a specific part of ethical duties, because that's something that's not just a legal ethical duty. Most people will have an ethical duty around conflicts of interest, and as the world becomes more complicated, it becomes a increasingly more difficult thing to manage. Still, a few people are struggling with precedent, and my reassurance there is it is hard, but just keep practicing and use participate in the workshop. We'll discuss this in the workshops this week, definitely. And it's one of those things, like many things, it's practice. applying precedent in practical situations, not just abstractly thinking about it, is the way to get better. And if we have difficulties, ask those questions. Ask them on Teams, ask them in the workshops. That's the way to go. One interesting comment there too was how to get the flow of arguing a case together, how to put all the pieces together, and that's great because that's the subject of this week's workshop and this week's challenge. So what I have been very pleased with a lot of these feedbacks, with the check-ins throughout the term, is how often people have said, what I would like more information about is this, and the answer is that's what we're doing next week. So I think that's good that we've that we have that sense of continuity, and people are asking the right questions, but we're about to answer. Another comment: we are being more frequently exposed to a range of different facts and scenarios in legal problems. Are there any tricks to rely on to accurately recall and present the facts? And that, I think, might come from a law student, and that's because when you're a law student, you study all sorts of areas of law at the same time, and it is frankly overwhelming. You're doing criminal law, you're doing tort law, you're doing contract law, you're doing everything. And again, when people are in practice, they all have their expertise, and they do the same thing over and over again. In fact, they often don't even really do much consideration of the law. Most of what they do is negotiate arrangements between people. So there's no trick to doing it as a student. It's just that difficulty of constantly learning about new areas and finding out what the precedents are. In practice, what happens is that you get your area of specialty, you use the same form letters, you use the same, they call them precedents just to confuse everyone, but they're basically like contracts and documents that are templates. So a template would be a much better term for it. But they use the same stuff over again and again and again. And sometimes firms will use things that are really old and out of date and have really bad legalese in them just because of, everyone's working to billable hours and everyone's just churning the work out. So it becomes much easier in practice because you are dealing with the same sort of thing over and over again. You don't have to keep learning new areas. In fact, probably what is more difficult is sometimes distinguishing between and keeping the facts straight about, okay, I do family law, is it this family or is it that family or whatever. But yeah, just reassurance that cognitive load that you have as a student is not what happens in practice. And it's one of those, we're really bound by the way we teach, by the accreditation society organisations, and the way they say you have to look at all these things and you have to cover everything. But it is overwhelming and it doesn't really allow as much time as we need to dig into subjects into depth. But at the moment, we are limited by the way in which we teach. So anyway, thanks for your feedback, guys, and I will see you in class next week. It's next week for me. It'll probably be this week by the time you see it. And we'll finally put all those pieces together.